The next matter to come before us this morning is State versus Leonard S. Yuncker. The appellant has waived oral argument. Mr. Kern, you have 15 minutes to present this case. We have read the briefs and we are ready to see when you are.
Thank you, Your Honors. Again, I'm Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. May it please the court. There are two assignments of error raised by the appellant, Mr. Yuncker, in this matter. I'd like to start first with the second assignment of error and then proceed to what I think is the gist of the appeal and the manifest weight issue. The second assignment of error challenges the proportionality of the defendant's sentence and does so by basically claiming that the trial court erred in imposing a prison sentence when it should have imposed community control. And I'll note that first, there is still an outstanding standard of review issue on sentencing appeals in the district. I know the court has traditionally favored the abuse of discretion review, but as effective in October or late September of 2011, the General Assembly has repudiated the abuse of discretion standard under 2953-08G and has clarified that the Court of Appeals, when reviewing a sentence, must uphold the sentence unless it clearly and convincingly finds that the record fails to support the trial court's findings. And especially in cases where the trial court does not have to make any findings. You just heard in the previous argument that the only time the trial court has to make findings in support of a sentence is when it imposes consecutive sentences under 2929-14C4. There are no consecutive sentences imposed in this case. The trial court, therefore, under State v. Foster and progeny, did not have to make any findings. So the court then, by conclusion, deduction, could not hold that the record does not support the trial court's findings because the trial court didn't have to make any findings. I'll also note that there is a presumption in favor of prison in this case because as a second-degree felony felonious assault, 2913D1 created a presumption in favor of prison, which the trial court determined there were no basis to depart from. The court imposed a 2-year prison sentence, which under 2914A2 was the least available prison sentence. 2914A2 says for a felony of the second degree, the trial court shall impose a prison term of between 2 and 8 years. The trial court imposed the minimum prison term in this case, the 2-year prison sentence.
The defendant here was 18 or 19?
I believe 18 at the time of the offense, maybe 19 by the time of trial, but yeah, just having attained the age of majority, because he obviously was charged as an adult.
Right.
But the trial court also noted that the pre-sentence investigation report, which I believe is part of this record, had previously been adjudicated delinquent as a juvenile, was 18 years old at the time of the offense, but the trial prosecutor noted at trial that the principal offender, Morton, received a 5-year prison sentence and 2 years was more appropriate in this case. So the trial court did take into account the proportionality of fashioning a sentence in light of the presumption in favor of a prison sentence vis-a-vis the principal offender, Morton, and vis-a-vis age and all the other factors the trial court was required to consider. It's not disproportionate to other offenses, nor does the appellant, either at the trial court or an appeal, clarify other sentences where this sentence would be disproportionate. It doesn't cite any other complicity to felonious assault convictions, doesn't cite any other felonious assault convictions where the trial court imposed community control sanctions, doesn't cite any cases where the court failed to impose a 2-year prison sentence. And to the extent that the trial court imposed the minimum prison sentence allowable under the statute, I don't really see how the sentence could be contrary to law in that sense. And unless there are any further questions on this assignment, I'll move back to the first assignment error. The argument in this case with regard to the manifest weight assertion is essentially that the defendant claims he was merely present at the house and did not have any similar culpability in terms of the principal offender. There's no dispute in this case that the principal offender, Matt Morton, discharged the .22 rifle, shooting Casey Dimitrov in the leg, causing serious physical harm. There's no dispute that, right, he discharged the weapon. There's no dispute that he shot the victim. The dispute in this case, from Mr. Yuncker's standpoint, is that he did not have any criminal purpose or criminal knowledge, as the actual mental state would be in this case, to assist, to encourage, or to otherwise be complicit in Morton's criminal offense. And the state at trial adduced several pieces of evidence in the form of testimony from Morton and from Mr. Dimitrov, both of whom testified, and from Sergeant Nathan Simpson of the Medina City Police Department, who interviewed Mr. Yuncker at the scene when they responded that evening. And the evidence indicated, and the jury found, that Mr. Yuncker knowingly assisted, encouraged, was complicit in Morton's felonious assault. And those facts included giving the rifle to Morton, transcript page 134 and 136 to 37, knowing that Morton was going to use the weapon, transcript page 113, going to the front window to look for Dimitrov, even though essentially the story of trial was, we thought he had left, we didn't think he was still there. Well, if that's true, why did you go to the front window to look for him as Morton is standing in the garage holding the gun? And then, after Morton shoots Dimitrov in the leg, and police are called, he says, we got to get rid of this gun, and Yuncker takes the gun and hides it back in the house while police are coming. Now, is that after Morton shoots Dimitrov? Yes, but as the House Supreme Court and this court have routinely noted, actions after an event can be indicative of a person's mental state beforehand. And in this case, the statement, we got to get rid of this gun, shows a shared common purpose, a shared common venture between Morton and Mr. Yuncker. There's also evidence...
Of course, that was Morton that said that.
I'm sorry?
Of course, that was Morton that said that, not
right.
the defendant here.
Right, but it shows Morton's understanding of the situation, that Morton received the gun. Yuncker tells Sergeant Simpson that, well, I knew he was gonna do it. I knew he was gonna do something, because when Morton says he's going to do something, he does it. So when Morton says, give me the gun, after they've already evicted Dimitrov from the house, there's no other reason to give Morton the weapon unless he intends to use it to shoot Dimitrov.
No, the gun was unloaded at first.
When Yuncker retrieved it from the upstairs bedroom of his father, is what the record shows. That it was, he claims it was unloaded because that's how it was always stored. But then, obviously, by the time Morton shoots Dimitrov, it's clearly loaded. The insinuation, the logical inference for the jury to draw in that situation is that in between the time Yuncker retrieved it from the upstairs bedroom and gave it to Morton, who never testifies to loading the weapon, he testifies to reloading the weapon in the garage, but he never testifies to initially loading the weapon, is that Yuncker loaded the weapon before giving it to Morton. That's the logical inference for the jury to draw there. And in giving Morton, who he acknowledges to Sergeant Simpson is going to use the weapon, in loading it, that's part of the evidence of his complicity.
Well, and at least that the defendant here retrieved the bullets as well.
I'm sorry?
Well, I understand your conclusion and your analysis and your reasoning that since Morton didn't say that he loaded, said he reloaded it, he just may not have talked about loading it or testified loading it. But the point is, at the very least, when the defendant went and got the gun, he had to also retrieve bullets for it.
Correct.
Unless you would assume or presume that Morton would carry around bullets and put that gun with him.
Right, and there's no testimony about that. So
Right, that's what I'm saying.
the inference for the jury to draw at trial, which in manifest way analysis, the defendant has to show, right, the defendant's burden is to show that the evidence in his favor clearly outweighs the evidence of the state in terms of the conviction, and there's just simply no evidence on that score. So in the absence of evidence, the court should default to the record, which shows that not only did Yuncker retrieve the weapon, but it was stored unloaded, and therefore, as a logical inference, he loaded the weapon, and as a logical inference of that, not to stack inferences, but the other inference from the fact that the weapon was unloaded and then became loaded is he also grabbed ammunition, at least a single round, to load into the weapon. The other thing that the state presented in this case is that Yuncker was upset with Dimitrov. Dimitrov, before being essentially evicted from the premises that night, had been hitting on Yuncker's girlfriend. Yuncker accused Dimitrov of stealing some other firearms from the father's gun collection, claimed that Dimitrov had been disrespecting the house by doing drugs, which admittedly is a little ironic since the testimony came out that basically all of them were either drinking or doing some kind of drug, although Dimitrov appears to be the only one who was doing heroin that evening. And Yuncker tells Sergeant Simpson that Dimitrov had essentially been trying to start a fight that night. So that testimony tells the jury that Yuncker is upset with Dimitrov that night. He's mad at him, he wants him out of the house, and in the process retrieves a weapon to get him out of the house, but then hands it to Morton and goes to the front window to look for him, expecting him to return. So handing the weapon to Morton, expecting his return, I think is indicative of complicity to have Morton shoot Dimitrov.
What's the testimony surrounding the first shot, the one that doesn't hit the victim in the leg?
So Morton, and I think this is Yuncker's version to Sergeant Simpson that evening, is that Morton shoots kind of a warning shot, and Dimitrov still proceeds up the driveway back towards the house. I think the jury might have been skeptical that that in fact was a warning shot. I think there's also a suggestion that as Dimitrov kept proceeding up and Morton goes to find another round on the table in the back of the garage to reload, that maybe that's not really meant as a warning shot, that he is maybe trying to hit Dimitrov from a distance, and either because of his impairment from intoxication or, Morton is older than 18-year-old Yuncker, but not significantly so. I think he's 22 from the record, if I'm remembering correctly. There's maybe the jury just thought he's a bad shot, and he really is trying to hit Dimitrov from a distance. Yuncker and Morton play that off as, it's a warning shot to try to get him to turn around. But that's the evidence in front of the jury.
Would it matter if it was a warning shot?
I don't think it does. I don't think it plays out in terms of whether Yuncker is complicit, because he still gave the weapon to Morton, knowing that Morton was going to use it to shoot Dimitrov. The fact that he was unsuccessful on the first try actually potentially strengthens the inference that, if you hear a shot from the garage when you're in the front window and you say to yourself, I didn't mean for Morton to use that, there would at least be some attempt. If that was the expectation, that he didn't have that complicity, you would expect Yuncker to move from the front window towards the garage and say, "What are you doing? Stop." There's no indication that happened. Yuncker doesn't even try to claim to Sergeant Simpson that happened. He says, I was in the house, and then I came towards the garage and I saw Morton shoot Dimitrov in the leg. He makes no attempt to stop that. He makes no attempt to control the situation. He sets the plan in motion. He is the one who gets the gun, gives it to Morton, and says, right, I knew he was going to use it, because when Morton says he's going to do something, he doesn't.
He didn't act, he didn't say anything to the officers that he was scared, and that's the reason he did nothing like that.
Correct. And in fact, right, Morton has, the second shot, there's at least the suggestion that there are additional rounds of ammunition on the back table. So Morton still has the rifle, has access to additional rounds of ammunition close by, but Yuncker still runs towards the garage after the second shot and tries to help Morton. So there is a clear insinuation in this record that they are sharing a common understanding, that they are acting in concert, which is the essential gist of a complicity charge, right? That Yuncker provides the weapon to Morton, knowing he's going to use it, and the jury could find that he supported, encouraged, assisted, or cooperated with the principal offender in the commission of the offense, knowing that the offender was going to commit this offense.
And counsel, you have reached the end of the allotted 15-minute time.
Thank you.